I'm Sachin Satpute, Chairman of ICCK. I'm also currently the President of Novelis Asia. Novelis is the world's largest aluminum rolling and recycling company, and we have a good presence in Korea. We have 2 manufacturing facilities in Korea, and we have our facilities in other parts of Asia, including China, but our Asia headquarters is in Korea, Seoul, Korea. I've been here for last almost 5 years with my family, and this is my second stint. Overall, I'll be staying now close to 9 years in Korea. So on behalf of Indian Chamber of Commerce in Korea, I would like to extend a warm welcome to all of you. Little bit about ICCK is now almost 10 years young now. Our vision is to play a vital and valuable role in economic development and trade promotion between the 2 countries, Korea and in India. ICCK has a steadily growing membership base of around 65 members. We help to connect Korean and Indian businesses to explore mutually beneficial cooperation opportunities. Yoon and Yang and KNS partner as our corporate member. We would like to connect them with several other companies who wish to explore Indian market. India has done well, in terms of economic growth, in terms of ease of doing business, and as per the latest World Bank's Ease of Doing Business 2020, India has jumped to 63rd position. That's a big jump from 142nd in 2015. And also, despite all the challenges you heard about, the COVID-19 situation and pandemic, the economy is still doing strong. With a fast-growing economy, skilled workforce, and huge consumer base, India is a high potential market for Korean business people, and who are already doing business internationally or looking to expand business overseas. The Indian market offers many opportunities, but it also comes up with own set of unique challenges, right? Understanding which sectors have the most opportunities or the highest consumer demand, as well as how to build a strong market entry strategy for India are just few elements that you should be considering for success in India. This webinar will give you the insights on patent, design, and trademark laws in India, which will cover overview of Indian IP system and particular provisions in Patents and Trademark Act that will provide any company a better perspective of IP strategy and best practices. Also from Korean side, Mr. Lim will give you some overview of protection of trade dress in Korea and in India. I hope you will find this webinar interesting and insightful. Thank you. Kamsahamnida.
Thank you, sir. So now I would like to present our first speaker, Mr. Chulgun Lim, who is a partner at Yoon and Yang, and his main practices area is handling disputes and litigation cases relating to the IP property. So he also covers patent, copyrights, trademark and trade secret, personal information protection and technology. He obtained his LLB degree from Seoul National University and LLM degree from Northwestern University School of Law. Mr. Lim is also licensed New York attorney and provides legal advice on various cross-border matters for multinational companies and domestic ventures. Welcome, Mr. Lim.
As you know, the concept of trade dress was first introduced in United States. So I will introduce some trade dress concepts in United concepts and protections in United States, and I will proceed to the protection of trade dress in Korea and in India, and differences of the requirements and the regulations in both countries. Okay. In the United States, the concept of trade dress was expanded with a time span. In the first time, it only means that the overall appearance of packaging labels, wrappers, and containers, but with a time span, the design configuration and shape of the product, the look and feel of the product, or the look and feel of service establishments was also included in the concept of trade dress. And after that, the appearance and decor of a restaurant, or the use of a distinct marketing techniques or market sales techniques was also included in the concept of trade dress in US. And the next slide, you can see that the most famous case in United States. This case was 2 pesos versus Taco Cabana. And as you can see, the pictures of 2 restaurants, the image or just the look and feel of the service establishments is very strikingly similar. And at the first instance, the court held that trade dress is the total image of the business. Taco Cabana's trade dress includes the shape and general appearance of the restaurant, the identifying sign, the interior kitchen floor plan, menu, equipment of the service food, and uniforms or other features reflecting total image of the restaurant. So at this case, trade dress was defined as a total image of product or service establishment as shown by its size, shape, color or color combination, textures, graphics, or sales techniques as well. And next slide is the statutory. Sorry for not good at handling this kind of material. So for the legislation, US provides a legislation for trade dress. If your trade dress is inherently distinctive, then you can register on the principal register. And if it is not inherently distinctive, you can register your trade dress under a supplemental register. And if you have acquired secondary meaning, then you can also register on the principal register. This registration is related to the famous Coca-Cola bottle of the Coca-Cola bottle. So in US, you need 3 requirements: non-functional, distinctiveness, and likelihood of confusion. And for non-functional, it is required because it is not. If it is functional, then everyone needs this kind of trade dress to be. Everyone needs this kind of. Everyone's have a need to use this kind of materials. And for distinctiveness, there are 2 kinds of distinctiveness. First is inherent distinctiveness, and second one is secondary meaning. If you have acquired, even though the characteristics is not conceptually separable from the product or services. And in the United States, in Walmart case, the Supreme Court told that the product packaging may be inherently distinctive, but the product configuration and design are not inherently distinctive. So if you want to have a protection for product configuration, you need to have a secondary meaning. It means that you have used it for a very long time, and consumers should have known that you are using this kind of a product configuration as your source identifier. And I will present about protection of traders in Korea. In Korea, there are no specific acts or regulations that protect trade dress. However, similar to US, if you have registered your trade dress as a trademark or as a design right, it is eligible for you to protect. It is eligible for you to be to have a protection of your trade dress in Korea. However, if you have not registered your trade dress, how can you be protected, or how can you have a protection about your trade dress? We have Unfair Competition Prevention Act, and there are so many clauses for Unfair Competition Prevention Act, and there are several court cases and precedents which could be used for your protection of trade dress in Korea. For Article 2(1)(a) and (b), it is a clause that if your mark is widely known to the consumers and your competitors use very similar marks to your marks, it is prohibited. So the question is, trade dress or shape, container or packaging of a product constitute marks to be eligible for the protection under this Article 2(1)(a) and (b). There are two Supreme Court cases. First one is shape of product and related to Mallory turtle. So you can see the two pictures of defendants and claimant. It is very similar. However, so maybe you can say that it is kind of trade dress or your trade dress. And the question is, this kind of trade dress could be trades can could be related to the marks that are protected under 2(1)(a) of the Unfair Competition Prevention Act. Supreme Court case stipulates that ordinarily the configuration or shape of a product does not indicate the source of the product. However, if you have used your configuration of shape on a continuous, dominant, and exclusive basis to the extent that it has conferred a distinctive character in the mind of the contractor or consumer, then maybe your configuration or shape of product can be your source identifier, and you may be you may have a protection under this article. So the court is saying that trade dress could be trade dress could be protected under this Unfair Competition Prevention Act, Article 2(1)(a) or (b). The second case is Korean Lab case, and the court held that Korean Lab has used this box and its color and its design for several years, and consumers had known that Korean Lab, it is widely known to the consumers and markets that Korean Lab is using this kind of trade dress, and in that case, you can have a protection. So I explained about Unfair Competition Prevention Act 2(1)(a) and (b), and there are several other clauses that also protect trade dress in the under the Unfair Competition Prevention Act. Article 2(1)(i) is the Article 2(1)(i) is related to the protection of dead copy product. So this one is related to the box or container of biscuits, and the court stipulates that the container or the packaging of the product form. The issue is that whether the container or the packaging of the product forms shape of the product whether it is eligible protection under Unfair Competition Prevention Act, Article 21I, and the court held that although the shape of product referred to in Article 21I of the Act does not ordinarily include the container or the packaging, in the present case, the packaging could constitute the shape of the product, given that without opening the package, the product that is contained inside cannot be seen. However, this article is related to the protection of dead copying product, and even though it is similar, it is not same or strikingly similar to the other project because there are noticeable differences between the two packages the two packaging. So the light one, Maroni, has not violated Unfair Competition Prevention Act when you have compared two packagings of these biscuit boxes. And the last article is Article 21K, and it is a general clause that protects that prohibits Unfair Competition Act, and there are two cases. First one is ice cream shop case, and second one is red bean bread case. In two cases, the court held that Trademarks dress it is under the Unfair Competition Prevention Act. The newly developed techniques or technical achievements, not only the newly developed techniques or technical achievements, but also the overall image of a service establishment. When taken together, we will enjoy the protection. When taken together, they are protected under Article 2. They are, even though the single elements are not protected by other articles, if it is taken together, it could enjoy the protection of trade dress, and it could enjoy protection of Article 21J of the Act. And after that, in 2018, there was an amendment of the Unfair Competition Prevention Act. And as I told you in the first case, where the issue was trade dress could be included at the mark under the Article 21A and B. The amendment of 2018 expressly stipulates that methods of selling products and offering services or overall appearance of a business place, such as signs, exterior and interior decorations, could be included, should be included in the marks if they marks that are protected if they are widely known in Korea. So with this amendment, we have 3 clauses that protect traders under the unfair under the protection of under this Unfair Competition Prevention Act. So to be eligible for the protection under this act, especially under the article of 2(1)(a) and (b), your trades should be widely known in Korea, and if it is if your competitor's trades is very similar to your trades, you are eligible the protection of trade dress. Even though I'm not expert in the trademarks law in India, I briefly introduce some cases and some regulations in India to compare the protection of traders in India and Korea. Similar to Korea, there is not specific provisions for traders in India. However, similar to Korea, you can register your product package or product design configuration as a mark in India. And aside this trademark protection, you can have a common law protection of passing of claim. In Korea, you are eligible protection under the Unfair Competition Prevention Act, and in India, you can have a passing of claim if your trade dress is infringed. You may need 3 requirements. First is reputation or goodwill, and second one is misrepresentation, and the second one is damages. And I will show 3 cases in India. First one is the toothpaste case, and as you can see, the color combination is very similar, and the court held that you are eligible for passing of claims because even though the mark itself, Colgate and Anchor, is different, unwary and illiterate customers can be confused about the source and origin of the goods because this similar color combination. And the second one is vodka bottle case, and it is very unique, and defendants has no bona fide explanation for using this kind of strikingly similar looking bottle. So you can have a trade dress protection under the claim of under the passing of claim. And the last case is a biscuit packaging case. I heard that there are so many cases between Britannia and ITC, and this is related to kind of a digestive biscuit. And you can see very similar color combination, yellow and blue. However, Delhi High Court stipulates that to be eligible protection, the yellow-blue combination should have gotten the secondary meaning, meaning that if ITC wants to, to enable ITC to prevent its use by competitors, this kind of yellow-blue combination, the packaging itself, it has the packaging should be should have acquired a secondary meaning, and if the illiterate customers have shown that this color combination of yellow and blue, then they can seek about an ITC as a source identification. So in summarization, I think that maybe trade protection in Korea and India is very similar, even though the basic rules and regulations are different. The underlying legal aspects are very similar, and maybe you can have a good protection about your trade dress. Thank you for listening my presentation. Thank you.
Thank you, Mr. Lim. Now I would like to invite Mr. Anand and Mr. Ashish for the presentation on India.
So before we go ahead with the different aspects of trademarks, which we our patents and designs, I think it is important for you to know about the IP scenario in India. So to start with, the first bullet, as you can see, it talks about the legal framework and the independence of judiciary in India. So in India, you have a legislative, you have administrative, and you have a judiciary. All of them are work independently, and therefore they are working independently and not interlinked. And therefore, there is a good synergy and system in place. Number two, it has one of the most robust IP systems in India. Today, you are able to get a trademark registration within 8 months' time, if everything is in order. It's much faster than your Madrid system. Number three, the IP expertise are reasonably good, meaning the profession, the system in place, which is there in India in terms of intellectual property. Let it be coming in training, because right now it's being taught in schools, it's been taught at the legal enforcement agency, at the customs, at the judiciary. So the importance of IP is being given with strong importance, and therefore its expertise level has increased. Number four, judiciary, generally it is pro IP protection. So you would see lots of judgments, as you has been shown by a previous speaker, that the judgments, the judges have been pro IP protection. And number five, the legal system in India, judiciary, is based on legal precedents. That means what judgments has been passed, those are relied upon. And those play as an active role to influence future cases. So you have a legal precedent system in India. And most important, number five, the second last bullet is absence of biasness against foreign IP owners. So it doesn't matter if you are not from India. If you have a strong IP case, you'd still be successful. And the last, we do have several measures which include civil, criminal, and border remedies. Next slide, please. So let's talk about trademarks and some important aspects which needs to be spoken on trademarks. If you could move. As we've said, registration is not mandatory. So how do you get rights in India? So you get rights in India into two ways. Number one, you get it through your use. So you launch a product, you sell in India, that is your commercial use. And that use, you would say that you've got attained common law rights. Can you press the button, Ashutosh? So that's something where you get common law rights. That's known as, it's not registered, but it's common law based on your commercial use in the market. And the second is through registration. The same format, you go and apply for trademark registration, and then that's called statutory rights. And next slide, press the button again, Tush. So here you have, and the registration certificate per se is simply an evidence to show ownership. So just to tell you, in India, use is more important than registration. So if you are able to show use, you have better rights. So common law rights play a very important role in India. Next slide, please. Some important aspects when you apply for trademarks in India. So you can apply based on user requirement. So you can apply on proposed to be used and have the application registered. And it becomes vulnerable for non-use after 5 years and 3 months. So for 5 years and 3 months, you are safe that you've got a registration. But after that, if you don't use, if someone applies for cancellation, then it will become vulnerable for cancellation. And if you've not used, then it will be struck off. Second aspect is licensing, which is very important. You can even license unregistered mark in India. And there's always a saying that in some countries it is mandatory to record the license agreement with the trademarks office. So in India, it is not compulsory. You can do it as an option. The only advantage of doing it is that the person who becomes recorded with the Trademarks Office has the benefit of filing a civil suit on behalf of the rightful owner. That is the only advantage. Next slide, please. So here there are four aspects which are very important. One is when you talk about assignment. In assignment, there are two important aspects that needs to be kept in mind. One is there has to be a consideration amount that has to be mentioned in the assignment deed. The purpose is for stamping purposes. Number two, it has to be mentioned whether the assignment is with or without goodwill. So there are different processes if it's with or without goodwill. Another aspect is the TM symbol and the registered symbol. The TM symbol is indicating that it's a trademark, is simply as an educator to the public to say that this is a trademark. It can be used any point in time, even prior to filing an application. Register symbol can only be used when it is registered, when your trademark is registered. If you use it before that, then it is a criminal offense. And a very important thing, there's something called well-known trademark concept, which is now recognized in India. It was recognized earlier through legal precedents and case law, but it has attained importance through the statutory inclusion of it in the Act itself. Next slide, please. So quickly, just to talk about enforcement. Ashutosh, please. Yeah. So in the remedies and IP enforcement are basically civil, criminal, and border control. Now, some remedies are available across. Now, when I'm showing this slide to you, patents are not available in criminal or border control. Trademark is available in all three aspects, including designs, including geographical indication, but not for patents. Patents is strictly only civil as of today. Next slide, please. So, talking about civil remedy, what is important is something called interim injunction. When you file a suit, the first and foremost step is you also file an application along with the civil suit, an application for interim injunction, meaning you are expecting to have some kind of interim restraining order against the defendant during the pendency of the suit. So that's an interim injunction application. That's a very important milestone, in fact, in India, because as you know, a civil suit may take years to be concluded. This interim application can give you some interim relief. Within 6 to 1 year, usually it gets concluded, the arguments and the whole pleadings for it. So you will be able to get some kind of relief for the time being till the final conclusion of the case. Next slide, please. So apart from this interim injunction, there is something called an ex parte order as well, which is not very unusual in India. So when I talk about ex parte order, I particularly talk about that when you file a suit in India, a civil suit along with an interim application, at the very first day of hearing, if you are able to convince the judge that you have a very strong case, the judge may pass an order in your favor, restraining the defendant without even the presence of the defendant in the proceeding at that point in time. So that's what ex parte technically means. And apart from having an ex parte order, you can also apply for having a local commissioner to visit the premise of the defendant to seize or do some inventory of the goods or products that are being complained of, and also to order the infringer or the defendant to provide a list of the source of the infringing goods. Next slide, please. So some important aspects that need to be looked at in terms of civil litigation. Damages is not like you get in the US. So damages is not the US style, as you would say in India. So that's something that you should be aware of. Another aspect is the markets in India are oftenly comprised of small infringers and not big operators. And these guys don't even maintain accounts of what they do. So, and also if you are able to catch them, I mean, they are not financially that stable or strong to even pay you some kind of compensation or something. Also, another aspect is that large-scale institutional infringement is not prevalent in India. It's very small. And as I said earlier, the interim injunction is an important milestone, because once you have an interim injunction, because of the delay of the litigation, the parties usually settle the matter. Next slide, please. So let me just explain some case law just to give you a sense of understanding. This one case, rainforest, is very famous, as you all know. So there was an Indian entity which also had rainforest and had the tagline, "A wild place to eat." Again, the defendant had found this in bad faith and kind of restrained the defendant. Next case, please. Here we have Taco Bell, which also makes Indian foods. And apparently, then again, this, as you'd see, the third bullet, which talks about ex parte injunction. So meaning here is, as I said, on the first date of hearing, the judge said, nothing doing, this guy needs to stop. Okay, next case, please. Here is a very interesting case. You see 7-Up on the left, which is the plaintiff, and on the right, you send 11-Up. The most striking feature is the ball between 11-Up and 7-Up. And that's a very copy which is there. And that, again, was found to be similar. Next case, please. This is fairly recent. Recent, I would say, pre-lockdown, pre-COVID. And this was Starbucks and Starbucks. And again, in this case, the court held that the word Starbucks and Starbucks was something similar. And the photographs of the outlets you can see on your right. Starbucks on the left, Starbucks Coffee and Co. on the right. There was a settlement anyway reached out. As I said, they got an interim order, the people settled. So settlement was reached, and then it was agreed that they would change to Sardarji Baksh. Next case, please. This is a COVID case, because at that time in India, sanitizers were on high demand. And this happened even during the lockdown. The courts heard this matter virtually. And in this case, if you see, it's Dettol versus Deftol. And Dettol is a very famous, brand, popular brand. And the court did impose some fine and cost as well. Next slide, please. Here we have H&M. Just important facts that maybe is relevant to highlight here when I tell you the importance. This case also talks about something to do with transborder reputation, which is a recognized law in India. If you see the first bullet, it gives you the facts. This says plaintiff is the prior adopter in 2005. When I say prior adopter, means international prior adopter, not in India. Defendant's adoption is 2011, meaning defendant adopted and used the mark in India in 2011. Bullet number 2. The court observed plaintiff's entry into India is subsequent. That means plaintiff entered into India after 2011, which would mean after the adoption of the mark by the defendant. Now, what the court held, the third bullet, Ashutosh, what the court held was that it is, given the fact that there's so much foreign travel and exchange of cultures, consumer are aware top brands. And the court held, even if you are subsequently coming into India, if you are able to show that the public in India is exposed to your brand prior to it coming into India in a commercial scale, then you could take reliance and support of transborder reputation argument and stop the defendant. This is exactly what happened here. The plaintiff was subsequent in India but prior internationally and was able to show transborder reputation and actually was able to restrain the Indian party. Next case. This is something which my the earlier speaker had spoken. This is another case which is talking about shape. This is Zippo shape. Interesting thing about this case is on the left is the real Zippo, which is written Zippo. On the right, there is no Zippo written. Despite that, the court said nothing doing. Anyone who is a smoker or anyone looking at even from far distance can make out it's a Zippo light. Next, please. This is, again, most of us would know, this is regarding the tractor. and they are always available throughout the world in the color combination green and yellow. And this was also protected. There was another entity in India who had actually started making tractors with this color combination. Another important aspect I said about well-known trademarks. Next slide, please. This is about well-known trademarks. It's a very old case, but it's a very important one. The most interesting part is you have this Mercedes-Benz tri-circle, and you have this man standing to portray the same. And this is, on the right, is in relation to men's undergarments. Now, Mercedes don't make undergarments. Despite that, the court held that, look, the tri-circle of Mercedes-Benz is very popular. It has attained well-known mark, and therefore any use of it in relation to any goods or services would in a way give a reference to Mercedes. So therefore, in that case, they have actually restrained, as the court has observed, that the name which is well known in India and worldwide with respect to cars as a symbol, a three-pointed star. Next slide, please. This is again Sony, and in India, this guy was selling Sony for sarong. They call it lungi in India, but it is a sarong which you just wrap around, which males wear. Again, the court held that even when the fields of activity are different or remote from each other, the mark Sony is well known, and therefore it cannot be misappropriated. So I've explained lots of civil remedies. I come to criminal. Next slide, please. And quickly, I just would like to mention there is a criminal remedy under the trademarks. You can file it through the police, or you can go through the magistrate. When you go to the police being an agency, you need to have a certificate or an opinion from the registrar of trade to say that, look, the registrar confirms, because the police is simply an investigating agency. It cannot decide nor adjudicate. It has to act based on certain documentation. Next slide, please. Quickly, there is a concept called plea bargaining. As you all know, plea bargaining is quite a common term, but in India also, especially in IP case, plea bargaining is a concept that is commonly used. And for us, what we do is, once the accused pleads guilty, we get three things from the accused. One is your undertaking, second is your compensation, and third is a public apology. So let me just show you a public apology, how it looks like. Next slide, please. So here is a public apology which was issued by an entity who was misusing Yamaha mark in India. If you see in middle somewhere, the one which is as known as Motorama having registered office, so it says that relating to so and so, I hereby apologize for using so and so. And you can see the last sentence is, my client further undertakes confirm we will not engage in any activity which shall violate the intellectual property rights of Yamaha Motor. So this is an example of a public notice that we do. Next slide, please. Some examples of some criminal raids that we have done in the past. This is an interesting picture. Why? Because it's not only the product which is infringing that was confiscated by the police, but even the packaging material and the labels were also confiscated. So anything that bears a trademark, which is a violation, can be seized and is seized. Next slide, please. So another picture here for maybe Sony speakers, just to show how the police actually take hold of the stock. And if you can see the second picture on the left, the police looking at how they stock these particular products. Next slide, please. So now I would like to simply talk about the border enforcement in India. Now there is an aspect that border enforcement in India, as I said, does not include patents. It was earlier, but it had removed because the technicality involved. So now it is only restricted to trademark, copyright, GIs, and geographical indications and designs. And it is only for imports, not for exports as of today. If you want to do for export, you need to address a separate letter to the customs. Important thing about border enforcement here, the recordation process is, if you register in one place, you can have it applied and technically applicable in all ports in India. So it doesn't mean that you have to go in each port. One registration can cover all ports in India. And it is a very useful tool, especially to curb the menace of counterfeits. Next slide, please. I would just like to talk about quickly, next slide, please, about trade secrets. As we all know, trade secret is an information which provides a business a competitive edge, and it's kept, it's hidden. You have a trade secret statutory protection or law in the US, but in India there's no specific legislation for protecting, and it is only done through confidential information. It's done by law of contract and principles of equity. So that's an important aspect that you should be aware of. So some examples, as you already know. Next slide, please. We talk about the drink Pepsi, which was actually introduced as Brad drink in North Carolina, United States in 1893 by Caleb. And he had made it in his drugstore where the drink was sold. And then he renamed it Pepsi Cola in 1898. Even till date, the secret is still kept. Another example would be your KFC secret 11 herbs and spices, which is still a secret today, and the Google algorithm, which makes our life very easy when you do research. So I think I end my portion of the presentation, and my colleague Anand will take it forward from here. Thank you.
Thank you, Ashish. And a very good afternoon, everyone. It's my pleasure to be here. So, Ashish, we can move to the next slide. So I've divided this next segment into three parts. First part is on the patent, and the second is on design, and third segment will touch upon few statistics on the Indian patent filing and Indian design filings. So India is a member of Paris Convention and also member of PCT. So both the routes available for filing patent application in India, Paris Convention as well as national fees based on a PCT application. India also has been designated as the International Searching Authority. India follows a substantive examination system for getting a grant of the patent. As per the current trend, we observe that it takes about 3 years time from filing till grant of the patent. There are 4 patent offices located at Delhi, Mumbai, Chennai, and Kolkata. They are administered by a single body. Next slide, Ashutosh. Yeah. So on the in terms of timelines and in terms of the key stages from filing till grant, after filing the national phase application, I've taken the example of national phase application, and the timeline for filing national phase application in India is 31 months calculated from the priority application. After expiry of 31 months and the application is filed in India, it goes for publication, and normally it takes about 1 to 3 months of time to get the application published. And as I said, there is a substantive examination is there in India, so the applicant has to file a formal request along with official fee for as a request for examination. The timeline for the same is 48 months calculated from the priority date. Anytime before this 4 years or 48 months time, the applicant can file request for examination. Once the request for examination is filed, the patent application proceeds for examination, and patent office issues the examination report. The applicant is given 6 months of time to file a response. This 6 months time can be extended by a maximum of 3 months. And once the reply is filed, there's another opportunity of hearing is given in case there are any further issues. And after filing a reply to the hearing notice, the application proceeds for grant if all the requirements in the examination report and the hearing notice is complied with. There are also 2 windows of opposition is present in India. From publication till grant of the patent, there is a pre-grant opposition window. Any party can file a pre-grant opposition. And after grant of the patent, within 1 year, any interested party can file a post-grant opposition. Ashutosh, we can move to the next slide. So some of the key pointers about the Indian patent system is claiming priority is important because India is first to file system. So it's very important to claim the priority in the application. The patentable subject matter includes process and product. Use claims are not allowable in India. There are certain category of inventions which are not patentable and excluded from patentability. Some of them would include mere discovery or mere of the new form or new property or new use of any material, mere new use of a known apparatus or mere use of a known process is also not patentable. Method of agriculture and horticulture, method of treatment of humans and animals, claiming plants, humans, animals, or parts thereof is also not patentable. Only exception is the microorganisms. Computer program per se, business mathematical method, and algorithms are also excluded from patentability. I will touch upon this particular aspect in little more detail in the subsequent slide, that computer related inventions are patentable. Only exclusion is computer program per se and business method and mathematical method and algorithm. And inventions relating to atomic energy are also not patentable. In terms of official fee, there is a extra claim fee and extra page fee is applicable if the specification of the patent application includes more than 10 claims or more than 30 pages of the specification sheet. There is a extra claim fee or extra page fee is applicable. We can move to the next slide. So as I said, that there is a requirement of filing request for examination. Also, there is also a provision of request for expedited examination, which was introduced in the recent years. And however, this provision or this request for expedited examination is available on only certain categories, like if the applicant is startup or applicant is a small entity, and if the applicant has selected India as international searching authority, and there are a few others. Also, there is a PPH arrangement which Indian Patent Office currently has with JPO. So that is also available for expediting the prosecution of the application or examination of the application. However, currently this arrangement is not available with Korean Intellectual Property Office. In India, after during the examination, once the first examination report is issued and the response is filed, there is no second examination report which gets issued as per the practice. And we have seen the Patent Office, in case there are any further objections, they issue a hearing notice, providing an opportunity to discuss the case with the controller and providing additional responses and amendments to comply with the requirements of the examination report. So that's expedite the prosecution of the application. Timeline is 6 months. That is without any fee. The applicant can file their response to the first examination report, and an extension which is available of maximum of 3 months, but that extension has to be sought in one in single request, and maximum of 3 months is available. The applicant can amend the claims during the examination also. However, there is a requirement under section 59 which says that claim amendment should not go beyond the scope of the originally filed application or originally filed claims. That is to say that claims amendment should not broaden the scope of the originally filed claims. So it's important to note while making the amendments in the claims. In case of hearings, there are also hearing adjournments which are possible. There are maximum 2 adjournments of the hearing can be possible, and each adjournment will not exceed more than 30 days. Indian Patent Office has been following electronic medium conducting the hearing. So video conferencing facility is available for attending the hearing, and also in addition, in-person hearing is also possible. So choice is given to the applicant that how they wish to attend the hearings. We can move to the next slide, Ashutosh. There is also a provision of getting the refund of the examination fee that you pay at the time of filing request for examination. So one can get a refund of 90% of the official fee or of the request for examination paid, provided the application has not yet examined and the Patent Office has not issued the first examination report in the application. Patent term in the is 20 years from the date of filing. Date of filing would be, in case of national phase application, would be international filing date, and in case of convention application, it will be the date on which the Indian application has been lodged. In case the first provisional application has been filed in India and thereafter a non-provisional application is filed, the date of filing would be the date of filing of the provisional application, and 20 years term is calculated from the date of filing of the provisional application. There are no patent term adjustment possible. So irrespective of the grant of the patent, the timing of the grant of the patent, the 20 years will be the time calculated from the date of filing. Also, it is important to note that in India, the annuity fees are not payable during the pendency of the application. They are payable only after the grant. However, the annuities become due from third year. So it is calculated from the third year after the filing of the application, and the applicant has to pay the accumulated annuity fee within 3 months from the date of grant. And thereafter, within 3 months from the date of grant, and thereafter the applicant can pay annually or consolidated for the entire term. Next slide. So on the computer related inventions, they are patentable, provided we are able to show that there is a technical advancement and there is a real world effect in the claimed invention. Also, if there are any hardware limitations and any physical interaction between the entity has been established and shown in the specification and claims, though the hardware features need not be novel hardware features, it is possible to get a grant of the computer related inventions. So however, some general paragraphs in the specification which are like on software implementation may create some problem. However, if we are able to show the technical advancement, it is possible to get a grant on the computer related invention. Next slide, please. So in this section, I'll touch upon 3 provisions of Indian patent law, which is to be kept in mind while prosecuting the application, also while filing the applications. So these are requirement of foreign filing license for Indian resident. The another one is requirement of furnishing details of corresponding foreign patent applications with the Indian Patent Office. And the third one is requirement of furnishing statement of working every year for the granted patents. So we'll see these 3 provisions in little more detail in the subsequent slides. Next slide, please. So as per section 39 of the Indian Patents Act, any Indian resident cannot undertake any foreign filing without seeking cannot seek any foreign filing first without filing an Indian application or without seeking a permission from the Indian Patent Office. Section 39 does not specifically say that the invention must be made in India. So also the definition of resident is slightly ambiguous. So therefore, it is advisable wherever there is any Indian inventor or developer are resident in India, it is advisable to get a foreign filing license if the applicant wish to file the application first in any foreign country and not in India. Alternatively, the applicant can file the Indian application first and wait for 6 weeks and then file a foreign application. There may be examples that there are multiple applicants, some inventors are from India, some inventors are from overseas, and there may be some joint development and collaboration and R&D services are happening in collaborative way. Then in such cases, there may be possible that some inventors are from Indian residents, some inventors are from foreign. However, as an abundant caution approach, we advise that to get a foreign filing permission from the Indian Patent Office. We observe that such permissions are freely given only there is if the invention is not relating to atomic energy or any defense related inventions. Next slide, please. There is also a requirement of furnishing details of corresponding foreign patent applications. So the related provision is section 8. It has two parts. So first part says that it is obligatory for the applicant to furnish details of corresponding foreign patent applications to the Indian Patent Office, and this duty is only it is only there till the grant of the patent. So after the grant of the patent is not required to furnish details. Also, under this provision, this provision does not require to give any further updates or status update on the developments. The second part of this section empowers the controller to invite and ask for information about the processing of the corresponding foreign patent applications. Normally, we observe that the patent office raised this requirement during the examination in terms of asking for copies of office section, search report issued in major patent offices, and also granted claims issued by major patent offices. Next slide, please. The term major patent offices is not defined. However, we understand that it would include USPTO, EPO, JPO, Chinese Intellectual Property Office, and Korean Intellectual Property Offices. It may also include any other office section issued by any other patent office which has cited some close citation which are material for novelty and patentability of the invention claimed in the Indian application. Section 8 requirement is a ground. Non-compliance of Section 8 requirement is one of the ground of filing opposition, both pre-grant and post-grant opposition. So it is advisable that we reply to requirement raised under Section 8.2 and Section 8.1 requirements diligently, fully disclosing any objections raised by any foreign patent offices which are relating to novelty and patentability. There may be possibility that the foreign document or foreign office action is not in English language. So it may not be required to give a full translation of the document, but a summary note or a gist of the office action which are giving details of the objections on novelty and patentability can be furnished. And as per our understanding, that would suffice the requirement. Next slide, please. There is another requirement of furnishing statement of working. That is, after the grant of the patent every year, the patentee has to submit details of whether the patented invention has been worked on a commercial scale in India. And that information is required to be submitted as per the recent amendment in the patent rules by September 30th every year. And the details for the period of financial year, that is April 1st to March 31st next year, that is required to be submitted by September 30th. So the principle behind this provision is that patents are granted to encourage inventions and to ensure that the patented invention is worked in India on a commercial scale and not merely to enjoy the monopoly. There is also a consequence of non-compliance of this requirement. It may attract a fine up to $15,000 US. And some of the statistics shows that people are, the applicants, patentees are filing statement of working. It is to be submitted on Form 27. Next slide, please. So therefore, it is advisable to diligently file statement of working by indicating whether the invention is worked or not worked. Information required under the worked category is approximate value or revenue generated from manufacturing or importation of the patented product. Importation is also considered as working in India. In case the patentee is filing statement of working and indicating the non-working category in the statement of working, some of the reason would include that invention is still under testing, licensee is being identified, and commercial feasibility is under study. and any other practical difficulties for importation, regulatory delay, etc. Next slide, please. So some of the acts which can amount to patent infringement, we can skip this slide. Can we move to the next slide? So as Ashish mentioned that in the patent there is only civil remedy available. The reliefs available is interim relief. The patentee can also seek an ex parte interim injunction, and also there are permanent relief in terms of permanent injunction and claiming damages by way of monetary compensation and asking for accounts for profits can be claimed in an infringement suit. Next slide, please. In this section, I will touch upon the briefly on the designs. So in India, design registration is possible, and registrability is the requirement that design for enforcing the design rights, it has to be registered. What design includes the features of shape, configuration, ornament, and pattern which are applied to any article by any industrial process such as manual, mechanical, chemical, etc. That is the definition as per the Designs Act. And so features would include any feature that can be judged solely by eye and basically contributing to the aesthetic appeal or comprising external features of any article. Next slide, please. Some of the example on the shape and configuration, and one can claim only shape and configuration and surface pattern, or also if shape and configuration has no novelty and only novelty lies in the surface pattern and design features only lies in surface pattern, one can claim the surface patterns only. Next slide, please. So as I said, registration is a prerequisite requirement to get the protection. Design, if it is not registered, one cannot claim any design rights during any infringement proceeding. Also, the key requirement is the novelty. Any disclosure made, or if the product or article is used prior to the filing of the first design application anywhere in the world, may affect the novelty of the application, and such design will not be registrable. There are certain exclusions, mode or principle of construction, and any functional part cannot be claimed in the design. Any feature of the design which which is there because of its intended function and does not does not add value to the aesthetics of the article will not be registrable. For claiming the priority or reciprocity from the first application or first foreign application, Indian application can be filed within 6 months. Also, as per the recent amendment in the design rules, India follows the Locarno classification, and application has to be filed at the subclass level, and the subclass which is closest to the product claimed article need to be mentioned in the design application. Also in India, you cannot claim multiple aspects or multiple embodiments in the same design application, and each design application need to be filed. Each embodiment has to be filed in the separate design applications. And the term is 10 years after the registration of the applications. The 10 years term is calculated from the date of priority, or in case there is no priority, date of filing of the design application. This 10 years term, it can be extended by another 5 years by paying the renewal. Next slide, please. A typical representation sheets. For a 3-dimensional article, the design office normally asks for 7 views, which includes front, rear, both side views, left and right, and bottom and top views, and 1 perspective view for a design registration. Next slide, please. Design registration, unlike patent, is fairly quick, and average time from filing till registration, it's about 6 to 8 months. And after filing the design application, we get examination report, and after responding to the examination report, if the controller has any objection, there is a hearing notice issued, and after the response to the hearing notice and all the requirements is complied, the design proceeds for registration. Design, also once the design is registered, it is important that the articles are marked with the word registered or any suitable abbreviated form of registered along with the registration number. It's very important because during the infringement proceeding, the defendant may claim that they were not aware, and it may affect the plaintiff's claim of damages during infringement proceeding. In addition, design application does not get published before the registration. Only after the registration, design application gets published. Can we move to the next slide, please? So yes, only civil remedy is available. Criminal remedy is not available in case of piracy or infringement of the design. Registered proprietor may bring in a civil action against infringer. They can claim injunction against piracy and also claim damages. Statutory damages is prescribed in the Act is 25,000 Indian rupees for every contravention, and the maximum total amount recoverable for any one design is 50,000 Indian rupees. In addition, the applicant, the proprietor of the design can also sue the defendant for damages based on the gains made by the infringer or any losses suffered by the proprietor. The lowest court to bring the infringement action is district court. Also, cancellation is available as a defense, and if the defendant is taken during the infringement proceeding, cancellation as a defense, then the entire suit of the design infringement gets transferred to the High Court or commercial division of the appropriate High Court. Can we move to the next slide, please? Next. Yeah. So this is the last segment of the of my presentation. So we have seen the increased number of filing. There's a small increase of about 5.67%. This is the data as per the IPNL report published for 2018-19 data. And we see that there's a significant jump in the number of applications examined by the Patent Office, about 41%. Also, grant also increased, and also disposal of the applications increased. Disposal means the application which are granted or or refused by the Patent Office. It also includes the application which are abandoned by the applicant, withdrawn by the applicant. Next slide, please. Some of the statistics on the design filings. We have seen an increase in the design filing as well. Also, design examination of the design application is quick, and we continue to see the pendency in the design application is about 1 month. We receive after filing the application the examination report in about 1 to 1.5 months time. Next slide, please. A country-wise breakup of the filings in India. The maximum number of applications are being received from US, followed by Japan, China, Germany, and Korea. So there's just a glimpse of the number of applications filed by various countries in India. Thank you. That's all I have in my presentation, and thank you so much.